Welcome, KSLU students, to this mandatory explainer. Let's get straight into it. Open your notebooks, uncap your pens, and pay strict attention, because today we are dissecting the exact structure you need to secure full marks for question 28 on the Indian Contract Act 1872. This is not a subject you can simply skim. Contract law demands precision. So today we're focusing entirely on two critical pillars: the delegation of authority and the modes of termination of an agency. Here is our exact structure for this lecture. Number 1, Introduction to Agency Framework. Number 2, Delegation of Authority Rules. Number 3, Sub-agent versus Substituted Agent. Number 4, Termination by Parties and Law. Number 5, Irrevocable Agency Conditions. And finally, number 6, Mandatory Case Law Breakdown.
Section 1, Introduction to Agency Framework. Subtitle, Indian Contract Act, 1872.
Agency is governed by the Indian Contract Act, 1872. It involves a relationship where an agent acts on behalf of the principal. Now, listen to me carefully here. I want every single one of you to instruct yourselves to literally underline the words Indian Contract Act, 1872 with a black pen on your exam script. Why? Because doing this immediately captures the KSLU evaluator's attention and proves, right off the bat, that you are fully grounded in the BEAR Act.
Heading 2, Delegation of Authority Rules. Subtitle, The Constraints of Agency. The general rule we are looking at is completely encapsulated in this crucial Latin maxim, Delegatus non potest delegare. I insist you memorize this exact spelling. It literally means a delegate cannot further delegate. Think about it. An agent is appointed because the principal specifically trusts their personal skill. Therefore, the agent absolutely must perform these duties personally, and they cannot legally pass the baton to someone else without facing consequences. However, as we all know, the law has to accommodate business realities. So here are the strict exceptions where delegation is actually allowed. Number 1, express permission by the principal. 2, implied authority, like through custom or trade usage. 3, the nature of work requires delegation. 4, ministerial acts, which means basic clerical work. And 5, emergency situations. I'm sternly advising you, format this section in distinct, unmerged bullet points on your answer scripts exactly like this. You need to clearly demonstrate all 5 statutory exceptions to the examiner.
Heading 3, Sub-agent versus Substituted Agent. Subtitle, Distinguishing Roles under Section 191. Now, it's absolutely pertinent to note the statutory difference here. A sub-agent under Section 191 is appointed by the agent, acts under the control of the original agent, and importantly, the agent is responsible to the principal for the sub-agent's acts. In stark contrast, a substituted agent is appointed directly for the principal. The original agent only selects them but does not control them. I explicitly instruct you to draw a high contrast comparison table just like this in your exam. When a sub-agent is properly appointed, the principal is legally bound by their acts. Make sure you make this conceptual distinction visually clear on your paper.
Moving on to Part 2. Heading 4, Termination by Parties and Law. Subtitle, Sections 201 to 210. The first category is termination by act of parties. We have agreement, which is the mutual consent of principal and agent. Revocation by principal, meaning the principal may revoke authority, and renunciation by agent, where the agent may withdraw from the agency. You must elaborate in your exam on how mutual consent, unilateral revocation by the master, or renunciation by the servant serve as the primary party-driven mechanisms to dissolve the legal bond. It is a relationship built on volition, so naturally it can be severed by volition. The second category is termination by operation of law. Step 1, completion of business or expiry of time. Step 2, death or insanity of either party. Step 3, insolvency of principal. Step 4, destruction of subject matter. And Step 5, principal becoming alien enemy. You have to explain to the evaluator how the law automatically steps in here. If the principal becomes insolvent or the subject matter is literally destroyed, performance becomes legally or physically impossible, right? The law absolutely does not wait for the parties to agree. It acts forcefully to end the relationship.
Heading 5, Irrevocable Agency Conditions. Subtitle, The Exception to Termination.
Irrevocable agency. The rule states that an agency cannot be revoked when the agent has an interest in the subject matter. So, what does this actually mean? Well, it means if the agent has a financial or legal right rooted in the property that forms the subject of the agency, this entirely freezes the principal's statutory power of revocation.
The principal cannot simply fire the agent to cheat them out of their rightfully attached interest. It's an absolutely massive exception.
Now, for the climax of your exam answer. Heading 6, Mandatory Case Law Breakdown. Subtitle, Elevating Your Answer Script. The Bush v. Alt. Do yourselves a favor and instruct yourselves right now to write this case name in a separate, boxed format on your exam script. Let's deeply break down the brief facts. The principal appointed an agent to sell a ship in the East at a specific price. But the agent, unable to find a buyer, appointed a sub-agent, Mr. Alt, in Japan to facilitate the sale. The ratio decidendi established that due to the vast distance and the specific customs of maritime trade, the original agent actually had an implied authority to delegate. The absolute relevance of this case is that it perfectly proves the implied authority and trade custom exceptions to the Delegatus maxim. It shows the examiner exactly why those exceptions exist in the real world. Our second landmark case is Smart v. Sanders. I literally demand that this case name be underlined with a black pen on your script. Here's the background. An agent, known as a factor, was sent goods to sell. This agent made significant financial advances out of his own pocket to the principal, using the goods as security. When the principal later tried to revoke the agency and stop the sale, the court stepped in. The ratio decidendi? The court laid down strict limitations on the revocation of agency, holding that because the agent had advanced his own money against the goods, he firmly had an interest in the subject matter. The absolute relevance here is that Smart v. Sanders is the definitive judicial anchor for the concept of irrevocable agency. We conclude our explainer today with a question that must guide your final paragraph. Have you ensured flexibility and legal certainty in your conclusion? When you draft your final lines for the evaluator, summarize how the delegation of authority is strictly restricted to protect the principal, yet smartly allowed in specific scenarios to keep commerce flowing. Frame the termination rules as a balance between party autonomy and the automatic interventions of the law. I'll leave you with this provocative thought. Consider how these meticulous provisions of the Indian Contract Act don't just find parties, but rather they ensure absolute legal certainty and trust in all modern commercial relationships. Master these structures, follow my formatting instructions precisely, and I promise you, those 16 marks will firmly be yours. Keep studying.